Right, so what we've tried to do, because there's only about 1,290 odd pages to run through from the rather hastily put together Brexit deal. What we tried to do is pull together the key points that we think are going to be pertinent to you. We've pulled it into 4 sections. Jed's going to cover off the first 2 sections, and I'll cover off the last 2 sections. But we thought if you want to raise questions, we do our best to answer them, but maybe we could raise them at maybe the end of when Jed's finished her slot, and then when I finish my slot. And then if there's additional things that we can help with following up on, then we'll obviously try and make sure that we put you and Adam point you in the right direction. For example, obviously employment of staff locally is going to be quite a massive concern, I think, for a lot of you. So what we have done is we've got a couple of people and organisations lined up who can help with the more specific conversations around what is needed for each country. So hopefully that is all things that we can pass on. So if you mind turn the page, please, Adam. Well, yeah, so Jed's going to cover off business and operations, and I will cover off the consumer booking conditions and supplier contracts. Okay, over to you, Jed.
Great, thank you. Okay, so first of all, on business, it's the Tour Operators Margin Scheme, which is also known as TOMS. The UK TOMS came into effect on 1st of January 2021 and applies to tour operators registered in the UK only. And what this basically sets out is that the tour operators margin will be standard rated for travel services provided in the UK. But for travel services provided outside the UK, the tour operator's margin will be 0 rated, and that calculation will be calculations to what VAT is to be paid will be based on the previous financial year's accounts. The current situation: EU members currently do not require third countries, of which the UK is now categorised, to pay VAT locally. And similarly, the UK does not require EU tour operators to register and pay VAT in the UK. However, this is one of those things that may be subject to change, because as soon as, say, for example, the UK decided to start charging companies to pay VAT locally, then I'm sure the EU countries would do the same as well. But at the moment, we have got that status quo maintained. Okay. The next slide, please. Great. So on to insolvency protection. And with regards to UK businesses selling to UK customers, there is no change. Your operators will need a UK ATOL licence, bond, or insurance required for the sale of packages or LTAs, linked travel arrangements, within the UK. So for UK businesses selling to European EEA customers, there is now a requirement to comply with the insolvency protection requirements of each member state to which you sell. So tour operators in the first instance should really check with current UK bond issuers, insurers, as to whether they can provide suitable insolvency protection arrangements for the relevant EEA member state. Or alternatively, where the tour operator has a subsidiary in the EEA, the insolvency protection arrangements of that EEA country and business may be relied upon under the mutuality of recognition under the package travel regulations. The other alternative is to consider establishing a legal presence in an EEA member state country, and that would have to be a physical presence in order to sell to those EEA customers. Okay, next slide, please. And then with regards to EEA businesses selling to UK customers, where you've got an EEA business selling packages or linked travel arrangements to UK customers, the insolvency protection would need to be obtained within the UK, so that'd be a UK ATOL, UK bond. Okay, just quickly on price changes in terms of selling. So just a reminder, under the PTRs, price increases are permitted for changes in exchange rates on the condition that the relevant B2C, so your customer terms and conditions, state that the operator has the right to vary the price. Any increase is notified to the customer no later than 20 days prior to their departure. and usually the first 2% of any increase is absorbed by the business. And also any increase of more than 8% does entitle the customer to cancel their booking and receive a refund. Any right to vary prices for non-packages, so this is if you're selling accommodation only, that's subject to the booking conditions that you've got in place there, but also with the Consumer Rights Act 2015, and that's all about fairness to the customer. Okay. Just quickly on passenger rights. So current passenger rights are to remain, so for coach, rail, inland waterways, and also for air. However, there's one piece of legislation there, which is the rights of passengers, which is the protection and provision of an assistance to disabled persons and persons with reduced mobility travelling by air. And that will not automatically apply to passengers departing from, transiting through or arriving at UK airports. However, carrier assistance will still apply, so airlines still have the obligation there where the airline is an EU airline. Okay, on operations then. For cruise, the International Maritime Organization and international law, current international law, will ensure that there's minimal disruption for cruises, so those should not be affected. And inland waterways, the operators of EU inland waterway vessels will need to be registered in an EU member state in order to operate. Insofar as trains and rail is concerned, the Channel Tunnel will continue to operate, and that will now start to fall under a bilateral agreement that is yet to be determined between France and the UK, but operations until that's in place should not be affected. And operators on cross-border services will have to comply with national and EU regulations, but this also includes ensuring driver qualifications are issued by an EU member state and recognised by an EU member state. On coaches, for occasional coach services, so these are not the ones that are, sort of timed on a daily, weekly, monthly basis. So for occasional coach services, the UK will comply with the EU Interbus Agreement, and this is where UK drivers can operate in the EU on their UK qualification. The only difference here really is the GB stickers will be required for UK registered coaches travelling overseas. And on to workers. So there's quite a few slides here in regard to workers. And this is probably where a lot of the changes have taken place, especially for travel. So the Posted Workers Directive, which was in place, has not been replaced under the Trading Cooperation Agreement. So this now means that workers are able to enter EU countries on a temporary basis for certain business activities. And the certain business activities include negotiating contracts and attending business meetings. That is allowed for up to 90 days within any 180-day period. Now, some EU member states have opt-outs, which they call reservations to this, that are in place and as part of the Trading Cooperation Agreement. So there are further country restrictions that exist in certain circumstances, and we're just going to quickly cover those in the next couple of slides. But for longer stays, the immigration, so that's longer stays beyond the 90 days in any 180-day period. The immigration rules of each EU member state will apply. However, in saying that, the EU member states can continue to operate with the Posted Workers Directive for up to 15 years, next 15 years, but each of those EU member states has to request that to the EU Commission in order for that to be in place. So next slide. Okay, so these are the list of reservations and opt-outs that some of the countries have got in place. So Cyprus, for the provision of tourist guides, travel agencies and tour operators services, that is going to need to be, there's a requirement there that there needs to be a nationality of a member state, and that's any of the member states of the EU. For Greece, third country nationals, so that would include the UK, have to obtain a diploma from the tourist guide schools of the Greek Ministry of Tourism in order to be entitled to practice the profession, unless there's a specialist language there that is not already covered by the group of guides within Greece already. For Spain, nationality of a member state is required for the provision of tourist guide services. And next slide, please. And for Italy, something similar is in place there as well. So tourist guides from non-European Union countries need to obtain a specific license from the region, the specific region in Italy, in order to act as a professional tourist guide. However, tourist guides from EU member states can work freely without the requirement for such a license. And the license is only granted to tourist guides who demonstrate adequate competence and knowledge. So there is going to be apparently some kind of test in place there as well. Okay. For Austria, the operation of ski schools and mountain guide services is governed by the laws of Bundesländer. The provision of these services may require nationality of a member state of the EEA, and businesses may also be required to appoint managing director who is a national of a member state of the EEA. And for France, this is not in place currently, but is set out in the Trading Cooperation Agreement as being a future requirement, and future has not been determined how long future is, as in how far away that will be. But France will require nationality of a member state for the supply of tourist guide services. Okay, and then as a separate category, there's a section in the cooperation agreement around short-term business visitors. And the idea is that short-term business visitors should not be engaged in supplying their services to the general public of the EU country. So, for example, a tour or a travel agent supplying services to the general public in an EU country, so selling to the EU people within a particular country, may fall under the scope of that restriction. However, British tour guides who are accompanying a tour that has begun in the UK, so it's originated from the UK, in addition to tour and travel agents, tour guides and tour operators attending or participating in conventions within an EU country, are permitted to stay in that EU for up to 90 days in any 6-month period. Okay. And then just to touch upon students, many of you will have already know that the Erasmus scheme, which allowed for free movement and education exchange between registered universities and educational institutions, is going to be replaced by the touring scheme, which is allowing travel and study at universities on a worldwide basis. And the details of the touring scheme are still to be determined as at the last look, that is, unless something has come out more recently. Okay. And on the common travel area, so this is a CTA, so basically there's a long-standing agreement already in place between the UK and the Crown dependencies and Ireland. The trade and cooperation agreement does not affect this at all, and British and Irish citizens can still move freely, reside and work in either jurisdiction, and access the social welfare benefits and the health services provided. So over to Claire, I think, who's going to...
Okay, thank you. Thank you, Jed. So moving on to consumer and booking conditions, if you could pass the page over, thank you, Adam. Well, the main news for all those that are hoping it was going to go away, I'm afraid, the Package Travel and Linked Travel Arrangements Act, the package travel regulations as they are not going anywhere. So despite the fact that we have an EU directive and we are Brexiting, the 2018 Act will remain. So you have to, of course, have a duty under that Act to advise customers of certain information. And given what is going to be the case with, I think, a lot of concerns around passports, visas, health matters, insurance, for example, what we are suggesting is that you include the links to the FCDO and NAFNAC in your booking conditions, which is a very neat way of doing so without you taking on too many obligations, because the advice is obviously changing very frequently, particularly at the moment with COVID and travel and FCDO advice. We'd very much suggest that you look at your business to consumer terms and conditions and update them for 2021 sales and bookings, and also consider those bookings that you've already taken for 2021. Do you need to give them any updated information, particularly around travel arrangements and changes for post-January 2021 travel? As far as visas are concerned, it's not as bad as we had expected, to be honest. So if you're in the EU Schengen area only, UK citizens will not require short stay visas for leisure travel, as long as it's up to 90 days in a 180-day period. This includes some visits for certain business activities where you can sign contracts, attend meetings whatsoever. Bulgaria, Croatia, Cyprus and Romania will not be counting visits to other EU countries towards the 90-day total in any 180-day period. And then helpfully travel for Ireland is excluded from the 90 and 180-day rule. They were supposed to be organised and in place already, but the European Travel Information and Authorisation Scheme, which is going to be a bit like the US ESTA, so an online visa, which will be valid for 3 years, that's not now going to be rolled out, we don't think, to the end of 2022, and that will cover all travel for EU member states, be valid for 3 years and cost €7. And just like the ESTA, it'll be an online application applied for prior to departure. There may be a need for airport transport visas for certain third country nationals. So if you're travelling on a UK passport, you'll be exempt, but the third country nationals will need an airport transit visa. So that's something to look for those of your customers that would affect. And that's when transiting via a member state, but not Ireland, Iceland, Norway and Switzerland. And that visa can be obtained from the consulate of the country where the transit will occur. One thing to note is that for travel, your UK passports, except for when travelling to Ireland, the passport should have at least a 6 months validity remaining on them and be less than 10 years old. And what you need to look out for is some passports run for more than 10 years, because if you check the dates at the back, they maybe had some extra months loaded on them from the last expired passport. The authorities made it clear that the 10-year will be a dead stop. So any extra time that was rolled on from a previous passport will no longer be included when looking at the 10-year validity, for the 10-year validity and the 6 months validity. So make sure you're looking at just the narrower interpretation of the 10-year period. So the main problem for people like me who always leave it to the last minute to get to the airport is that border checks are going to be longer for us. We can no longer use the EU and EEA passport customs channels. So there should be advice given to customers to make sure they get to the airport early to avoid missing their plane. And then obviously they're going to be having to give evidence of passport validity. They might be quizzed on purpose of travel. They might want to see the ticketing. Some people may be asked to provide information as sufficient funds for the duration of the stay. So I think we can expect longer waits and a little bit more bureaucracy as we go through border checks. They've now decided that we do not need international driving permits, but apart from you may do in Norway. So as long as you've got the new style credit card style driving license, that should be fine. We will, however, need green card insurance. So you need to, or customers need to advise their insurers before coming over to the EU and make sure they've got a green card. And you need to be advising them that that's going to take them probably at least a month to obtain, and there is a cost involved in this. The good old GB stickers are going to be back unless you've got a registration number plate which displays the GB or the UK upon it. They have now actually put ECEX back in, so the European health insurance cards, which we were told previously were going to be out, are now back in, and they're going to be valid for travel in the EU. Apparently we can use a UK passport to get emergency treatment in Norway, but that's just a singular issue for Norway. And once the ECEX card has expired, we will be able to apply for the UK Global Health Insurance card, which was very similar, sort of mirrors the system. Where you're travelling to Switzerland, Norway, Iceland or Liechtenstein, you should ensure we've got sufficient travel insurance in place to make sure it also covers medical treatment and expenses. And there's probably going to be additional health checks, vaccinations, quarantine requirements, due to the joys of COVID. So again, that's why we suggested the easy click through to NAFNAC's website, which is very easy to understand and kept up to date all the time. For those with pets like myself, and we're very upset about the loss of our pet passports, you need to get to your vets early. They're saying at least to allow 1 month to obtain an animal health certificate. My vet's told me 6 months, so I suppose that people need to be pre-warned in that respect to make sure everyone's got the documentation and vaccinations for their dogs and cats and ferrets. Tax-free shopping, so we will be entitled to duty-free shopping. But we're going to have to queue up for it and present the receipts and credit cards, etc. at the departure airport upon return. So there'd be more queuing involved there. So again, more time needed at the airport. We should give suggestion that travellers should check to see if there's an English embassy, high commission or consulate in the country to which they're travelling, just so they have the details should they be required. And then the nice thing about food and drink, I was recounting to Adam a story that I'd recently heard. Any meat, milk or products containing them are not permitted to be taken into the EU. So apparently at the ports there is a very ferocious group of officials from Belgium and probably France as well, asking all the truckers to pass over their poor sandwich boxes, and they were confiscating all the food because now we cannot, of course, bring anything, any products containing milk or meat into the country. And apparently not even the bread was allowed to be retained, so maybe something to flag if they're going to continue being quite so stringent in that respect. Just over the page, Adam, if that's okay. Thank you. We're back to mobile roaming fees. So UK mobile operators can charge roaming fees from the 1st of January, though they do still need to give data notifications if they're going to be charging us more than £45. And then the only things that we would suggest you're going to think about in your booking conditions, I think most of you now have got Brexit clauses to look at the unforeseen consequences, consequential loss and indirect losses. But make sure that you've got in your force majeure or your unavoidable and extraordinary circumstances, check you've got pandemic or endemic in there. Look at whether you're going to be including no compensation in the being paid for unavoidable and extraordinary circumstances to protect yourself, and make sure you've got the right to offer alternative dates, alternative trips, and use refund credit notes to try and use or keep your cash flow going. Data protection. Jed was horrifying me earlier by telling me that with the removal of the union of being in the EU, we were going to have to be almost like the Americans, and we're not going to have the benefit of working with the GDPR, which obviously our own act is mirroring the GDPR, which is the EU directive. And the alternative was a 19-page clause to go into contracts, which filled me with horror. We're waiting for the EU to confirm that they are happy with our Data Protection Act, which, given it mirrors the directive, you would hope they would be. So we've now got a 4-month period, which is possibly going to be extended to 6 months to allow personal data to be transmitted until we get the adequacy decision. So fingers crossed we get it, which means we don't need to include the standard contractual clauses at the moment in your business-to-business contracts. But your transfer of personal data should still comply with the GDPR and our own Data Protection Act. So business as usual in that respect. You do need a representative, however, so you need an appointed representative under the EU version of our GDPR. So where there is processing of personal data of data subjects, so where you're processing people's data and they are in the EU and that it's being processed by someone who is not in the EU, i.e. us in the UK, and where these processing activities are related to the offering of goods or services to people in the EU, we will need an appointed representative. So just need to think about who that would be in your organisation. And then finally, you need to think about insolvency protection. So you need to include in your terms and conditions what you're doing for insolvency protection for the UK sales, but under the directive and the Act, you also need to look at what you're doing for the EU sales. So think about your UK customers, your European customers, and then also be happy to note that your US customer sales will not be affected by Brexit. So those who are dealing with the US can carry on as before. The joy of dealing with chargebacks continues. ABTA are aware of the very disparate approaches that are being taken by the different cards, the card providers such as Stripe and the like. We have been working with ABTA, and I think it's just a matter of flagging with ABTA the issues you're having. We're investigating the appeals process for a number of clients at the moment, so we'll keep Adam in the loop there if you're having any particular problems. Where there are airline refunds, you're probably all aware by now, as you've been dealing with them, but if the flight has actually been cancelled by the airline and doesn't take off, then your passengers are entitled to cash refunds, and they should be due and payable. You need to flag it with the CAA if people are dragging their feet, and ABTA, I think Paula at ABTA is also monitoring those airlines who are rather slow to put their hand in the pocket, and again flag it to Paula and she will raise it with the CAA if you're having problems. If the flight has not actually been cancelled, despite FCO/DO advice telling the people that they can't fly, so a lot of planes are taking off empty, then the airline only has to issue a voucher or offer the ability to rebook. They do not have to offer cash refunds, so just be aware of that. As for the good old FCDO advice, as you now know, there's pretty much nowhere we can go, but the travel advice is, of course, by country. It's something that changes daily, so if you haven't already signed up to their e-alerts, then I very much suggest you do so for once we were allowed to go travelling again. It's a very quick and easy system. So we need to check whether the country is on a corridor, the travel corridor list. What you might find is if we are allowed to travel and the country is on an allowed list and the flight is operating, but maybe a tier 4 or tier 3 lockdown prevents your customers from travelling, you can rely on your booking terms and conditions, but it's now argued that frustration of contract may have occurred, and in those consequences or those circumstances where you are able to provide the holiday, but it's the traveller can't get there without breaking the law, the advice from ABTA and the CMA is that you should offer a refund for any costs that you manage to recover. So if you get some money back from your suppliers, or if your plane tickets for their product could be refunded if the flight's operating, but if you get some money back from the hotel, then you're allowed to deduct some sums for your costs incurred, but maybe pass the balance back to the customer. Thanks, Adam. So just very quickly, because I think this is, Adam said this was probably something you didn't want to worry too much about, looking at supplier contracts, the clauses you would want to consider. First of all, what currency are you going to be using? Euros or good old British pounds? Do you want to think about fixing or capping your rates so you don't have huge currency fluctuations? Do you want to link it to a currency model like XE or something similar? Do you want to hedge your currency to secure your rate? So these are all things you need to be thinking about when you're looking at supplier contracts. If you've got a lot of prepayments and deposits and pre-agreed rates that are going to go up and down with fluctuations, you need to maybe think about your ability to suspend or renegotiate if things go wrong, as in force majeure, termination of contract, or notification of material adverse changes. So think about the worst case scenario and then how you're going to protect yourselves in your supplier contracts in that respect. Make sure you've got a right of set-off, make sure you've got a right of set-off, and I probably push back on rights of set-off against yourselves, so that if you've actually got monies that are due to you, you can knock off any sums you owe your supplier from those sums due. Then check your payment terms. Obviously, cash flow is going to be critical these days, so you know what happens in respect to your invoice payment terms. Do need to vary those to make sure invoices are paid more quickly. So the material adverse change clauses, you want an ability to either renegotiate your contracts or terminate your contracts, and the triggers for that would be maybe changes in booking and capacity, volumes, changes in currency rates, changes to resorts and destinations, maybe being shut down due to COVID or whatever reason. So make sure that's picked up. When you're looking at termination and notice periods, Are you going to want to terminate at any time for any reason on your side to give you flexibility? Do you want to have termination for certain events, the effects of Brexit, force majeure, big currency fluctuations, complete decrease in bookings? And think about your notice periods. Do you want more notice than you'd normally have? Do you want to extend notice periods to 3 months or 6 months? So just think about what's going to be important to you in your contracts with your suppliers. The exclusion of liability, you're going to want to exclude liability from yourselves for the unforeseen consequences of Brexit, because you don't want to be saddled with that. And then any consequential loss and indirect loss. Think about your force majeure clauses. Look about, what have you got in those clauses with your suppliers around the pandemic? Can you withdraw from contracts? Can they withdraw from contracts? How do you get out of the commitment that you've signed up to? And think about whether you need the right to suspend obligations and be able to renegotiate or terminate after X days of dealing with the force majeure situation. Do you need to give notice of what you call a force majeure event? I think with the joys of Brexit and the paperwork and bureaucracy it's going to come with it in various countries, make sure you've got provisions for the delays in obtaining any licenses or permits, and think about if it's going to be you that's going to be having difficulty, think about how you're going to continue with services. And if it's going to be a supplier and you need to ensure they're going to have the license or the permit, or it leaves you high and dry, then you might want to make that a condition precedent, something they have to do. I think it's going to be very essential that you have in your contracts the right to vary certain contractual terms. And then what you also need to be looking at is things such as what's going to happen with the vaccine. Do you need to think about material adverse changes in your contract? As far as novation is concerned, which is when you are trying to change your contracts, do you have to terminate them and start them again in a different country? Can you novate them and change the contracting party to an EU company in your group to help you reduce the risk to your company? That might be something that's an easy way for you to transfer the risk. And then thinking about your supply contracts and data protection, any data that you're transferring to the EEA, and you might need to be doing a data protection impact assessment, which is basically just an assessment to understand your flows of data from personal data from a controller to processor, controller to controller, which is a good form of risk management, and it shows good due diligence systems in your business. Key, probably the most final thing on the page, is making sure you've got a chain of indemnity in place in your commercial agreements, because if you're going to have to be paying out sums, you want to make sure that you're getting your money back from someone else. The good news is English law is still valid for business-to-business contracts. We are applying to join the Hague Convention, which would mean that we can sue within the EU different member states, and we can still have the exclusive jurisdiction of the English courts. So it just means it's much easier to sue people, which is always good when it comes to your supplier contracts. You might want to think about including an arbitration clause with a specified seat, and the seat, we mean the court that is going to be used, or the jurisdiction that's going to be used. So we would always argue for London, and that's valid under the New York Convention too, as an alternative form of dispute resolution. So just thinking about if something does go wrong, how you're going to get your money back and sue to recover losses. So that's our whirlwind tour around Brexit. So we just wondered if there are any questions that you wanted to put to us that we could try and answer on your behalf.
Thank you very much, Claire and Jed, really appreciate that. So yeah, there absolutely are a few questions, and I've got a few questions as well. So first of all, would you just recap, very kindly recap on the rules around a UK limited company selling to EU nationals and vice versa? So I think just to get that clear, and is there a difference if you're selling something that would fall under the package travel regulations versus selling something that doesn't fall under the package travel regulations?
And I'm presuming that's looking more at the financial protection that's going to be needed for those sales.
And around, and around the insolvent, yeah.
Jed, do you want to kick off and I then jump in?
Yeah, so this was slide 5 and 6, I think, wasn't it, around the insolvency protection. So as part of the package travel regulations, if you're selling packages or linked travel arrangements, there's an obligation there to provide insolvency protection for what you're selling. Just to recap on those three categories that we've put in the slides. So if you're a UK business, a UK registered business, and you're selling to UK customers, there is no change. It's still the same ATOL license, the bonds or an insurance that you may currently have already in place. Now, the change comes is if you're a UK registered business and you're selling to customers who are within the EU member states. So now there's a requirement to comply with the insolvency protection requirements of the member state, or of each of the member states to which you are selling to. And what we're saying here is that your current insolvency protection providers who provide your insolvency protection for UK may have something that you could potentially use for sales to EU customers, just as an inquiry to make to them. Now, there's the mutuality of recognition is part of the package travel regulations scheme, and what we're saying there is that where an operator has a subsidiary, an existing subsidiary in an EU member state, that subsidiary will have insolvency protection in place. And because of the mutuality of recognition, that insolvency protection that subsidiary has in the EU member state may also cover and be recognised by other EU countries, allowing you to sell in those EU member states. I hope that makes sense. I confuse myself sometimes with it. Kyra, have you got anything else to add to that?
I think what we understand, been speaking to John de Vial, obviously does the financial protection at ABTA on this subject, and I think what is happening is, and maybe it's not a surprise, is that some countries who obviously do not have the same ATOL or ABTA bond or insurance arrangements that we do here in England for our financial protection are insisting that in those countries, if we want to sell to those customers, that you would need to obtain the bond that is used in that country. So I think what is going to be important is if you don't have a subsidiary company with a base in the EU that can cover off the sales for you, then you're going to need to look at what countries you've got EU customers in, whether they will recognise the good old ABTA bond or the ATOL or your insurance policy. And if they don't, you'll be forced then to get if you want to continue to sell to those nationals, you will have to obtain their bonding. Although the protection may be very similar to what we have here in the UK, it just means that yours will not be valid.
Okay, so very much speak to your insolvency insurance provider in the first instance for that initial query, I think is helpful. We've got a bunch of questions. I'll try and stick on this theme. I've got a question that came in on email to me, so I'm just going to read it out. And again, it might be quite specific, so we might need to kind of deal with this one at a later date. I am the director of a UK limited company which is registered in the UK. I was a British resident until March last year, but now I've moved to my homeland, which is an EU country. I run my tours for my UK company solely outside the UK. In the future, I might decide to run some tours on the UK ground as well. I'm not a British national. Do I need to apply for a frontier work permit? Is question number one. And when working in the EU for my British company, do I need to have any extra requirements for business travelling? I'm assuming not, as they are an EU national.
No, I think for business travel as an EU national, you'll have freedom of travel. And actually for business travel, even if you're a UK national, you've got the ability to travel to sign documents and the like. So that should be fine. As for the frontier pass, I don't know, Jed, if you've got visibility on that or if that's too detailed at the moment.
Yeah, I think we probably need to take that one away if possible, and get back to you on that one.
Sure, no problem. Well, I'll make sure we get back to you. I think you probably know who you are from the way I read your question out. Just sticking with the location of your company, there was a question on the chat which basically said, how would anyone know if we sold a trip to an EU member? I'm guessing you wouldn't know. It's just that you have to have those relevant protections in place.
But presumably they give their names and addresses for the booking.
Sure, I guess it's probably around. I guess it's probably around what is the what's the risk. So if you still sell, still sell your products to EU nationals or vice versa, and don't make any changes to the way you operate your business, what is it? Can you get away with it? Essentially, is how I interpret the question.
I suspect, having seen how the lovely different nationalities of the EU are reacting to us post Brexit, that there will be a number of checks and balances. Like we have the CMA and trading standards who monitor what we do on sales. I think there will be people, I think you'll probably have secret shoppers and those sorts of things. So I think a bit like the CMA, they will start to either get complaints or they will look at trying to book trips pretending to be X or Y. And I think that's how they'll build their evidence. Not that I'm cynical.
Okay.
And just to follow up on Claire's point there as well, I was speaking to somebody from ABTA, and they were saying it's probably your competitors in destination who will shop you.
That's true.
Because they're going to want the additional business that you're theoretically taking away from them.
Right, understood. Okay. And so how different is it for a London-based tour operator who does tours of London by day, and equally same question for, let's say, a Rome or a Barcelona-based tour company who does local experiences. They're not actively marketing to in the EU or in the UK, but their tours are perfectly bookable online. Does that protection still need to be in place? How is that? Are the rules only in place if you're actively going out and promoting your services in the other country, in the other region?
I think the way that the package directive is worded is if you offer for sale your products and they are purchased by an EU national. So an offer for sale can be in many ways, shapes or forms. So it could be advertising on the side of your bus, it could be advertising on your website hosted in UK, or it could be an old-fashioned brochure. So I think it would be interpreted quite widely. Okay. And like Jez says, I think it's going to be your competition dobbing you in.
Okay. Right. So find out who your competitors are and get friendly with them. But
be nice to them.
To be quite honest, in the tour operator world, we should all be doing that anyway.
Yeah.
So within our interest. Okay. Let me just have a quick look at a couple of the questions. Yes, this is being recorded and we'll share the presentation. So, okay, let's start at the top here. So I think we've answered the one about insolvency. A lot of questions about tour guides and tour managers. And I had this question actually to ask, and I think I know the answer because I think I'm guessing the answer. Tour guides, or tour, I guess in Europe and the UK, we call them tourist guides, are very different from tour managers, tour leaders, tour escorts, whatever your terminology of the tour operator you work for. Are they separated in the eyes of the trade agreement, or is it too early to say yet? Because if you're a tour leader taking a group of people through Spain, you might not be providing the services that a qualified local tourist guide would provide. But are you seen under the terms of the agreement as still a tourist guide and providing those tourist services, which means, you would fall into that category of not being permitted, because there does seem to be a little bit of contradiction around that. So that's kind of one part to that question. And then secondly, which bit of the agreement overrides the other? Because if you start in the UK and travel into Europe, the rules say that you can continue to guide and provide the tourist services, but the other side of the rules say that you have to be a French national or a Spanish national, etc., to provide those tourist services. So which one would win? Which is it, I guess, is the question. Does that make sense? I seem to have done an awful job of asking that question.
Picking up on the second part of that, I think the key thing there is where the tour starts. So if the tour starts in the UK, it's fine.
Right.
That's permitted under
Okay.
the trading cooperation agreement.
So that overrides the necessity to be a local national in
Yes.
places like Austria and Spain and France at some point whenever they decide to change.
And that's because it falls under the scope of short-term business visitors, which
Right.
is a separate part of the trading cooperation agreement.
Okay.
So as long as the starting place is in the UK and it then travels into Europe, as far as that trade agreement goes, it's okay as long as it's the 90-day within the 6-month period. It falls within that.
Fine. And there's a few questions around that period, if I can just kind of shoehorn another one in there, Jed. So somebody's asked, does this mean that any UK tour manager can only work a maximum 6 months a year in the EU? I would normally have worked around 8 to 9 months a year. And I guess the logical question with my kind of old operational hat on is, if that tour starts in the UK and crosses into Europe, as the vast majority of the tours do, does the tour manager have to also cross over, also start in the UK, or can they remain in destination? Because traditionally what tour operators would do is plan their departure dates so that they start and end on the same date, and the tour manager can stay in destination and wave goodbye to one group and say hello to the other group pretty much off the same flight. But then under these new rules, that tour manager hasn't actually left the UK and crossed the border with the group. Is it too early to tell?
It doesn't. The agreement doesn't sort of like expressly provide and explain that situation.
Sure.
But I think what we can do is we can send you a summary of each of those two parts to the agreement. So the short-term business stay, which is the starting of the tour, which does say that the tour needs to start in the UK, for example, whereas the other side, the short stays, that's when it's the 90-day within the 180 days. So they might be able to fit into that category in
Right.
terms of the number of days collectively that they stay in the EU. But each of the days are counted from when you arrive in the EU. And
Okay.
it doesn't matter, it's collectively in the EU as well.
Right. Okay. So when you reach your 90 days, it kind of continues to roll on.
So if you've reached your 90 days within the 180, you need to get out and you come back in again to start your new 90 within the 180.
Right. Okay. I understand. Okay. Hopefully that makes sense to the person that asked that question. So somebody's asked, being an EU citizen, if I'm with a group in Spain, as long as I'm a certified guide in any EU country, can I lead a British group on British soil as an EU citizen? So I guess it's the same, but the other way around. So can a European-based tour manager lead a group in the UK, and how does that work? And again, is it the same thing? The tour has to start in Spain or the relatively EU country?
So that was an EU guide
Yeah.
starting in EU and coming into the UK.
Correct.
Yes, it's reciprocated. Yes.
Reciprocated. Perfect. Okay. Thank you. Okay, I think we've only got 2 minutes left and probably about 10 or 12 questions we haven't answered. So I'm going to beg some more goodwill from you both and see if we can answer these questions on email at a later date. So if I can email you these and we can get some constructed answers to them, and then I can share those with everybody who's attended today and everybody who's registered. Is that okay?
Yeah, no problem.
I don't want to take up any more of your time. Last thing to say, I'm sorry to everybody that we haven't got time to answer all those questions. They're great questions. I will get the answers out to you, I promise you, on behalf of the lovely Claire and Jed at Kennedy's. So thank you so much to you two. Really, really appreciate that.
Pleasure.
I kind of knew that we'd end this session with more questions and answers, and that's no reflection on your presentation at all. It was fantastic, but just a reflection on the scenario. So thank you very much to you both. And thank you to everybody for tuning in and taking part. And thank you very much.
Yeah, thank you, Adam.
Cheers.
Thanks, everyone.
All right. Bye-bye. Bye.